Welcome back, ladies and gentlemen, and it's once again coming across to personal law versus a common code. Can one particular law or interpretation as far as Shariat or their own personal law for a particular community or group, I'm saying Shariat because in this case the matter pertains to Muslim personal law, be it in the Karnataka court or even in the Kerala court. Can that supersede what should be applicable? So we talked about POXO. Now again, the right to call for divorce. Can certain clerics decide and hold sway over whether or not a woman can call for khula? What is the interpretation of the Shariat? Can it be apportioned to certain individuals who call themselves custodians of the law, or somebody who has studied or knows the codes by heart? By knowing something by heart, do you understand it, or are you then using it as per your own interpretation? Now, these are aspects which the court has also gotten into. Court saying that the Islamic clergy can't decide applicability. The court's also saying that courts are manned by trained legal minds. Not everybody can become a judge. I may know all the laws, but does that make me a judge or make me a lawyer? No. So you have to be trained for it. So that's what the courts are coming out and saying. This is the Kerala High Court which has opined on this. So the Karnataka High Court has annulled Muslim minors' marriage, saying that POXO prevails over your personal law, which says that the moment a woman attains puberty, a girl attains puberty, you can get her married off. Kerala High Court saying trained legal minds must prevail in courts. It's not an individual's interpretation of a particular personal law. Kerala High Court refuses to review the right of Muslim women to terminate marriage. Personal law is not about POXO. So, in this case, what the argument once again boils down to is, should we as a country be one nation with one law, especially for those which are aspects of personal contracts, marriage, inheritance, divorce, adoption, death? One nation, one law is the hashtag. And the debate revolves around this very matter. Courts joining in to this entire call of common code. That's what we are asking. Let's go straight across to this face-off. We have our guests with us this evening, Asghar Khan, Advocate Supreme Court, and Aishwarya Mudgil, Advocate Supreme Court. Namaste, ladies and gentlemen. Thank you very, very much. Thank you for joining us here on this. And it's a straight face-off. So, Asghar ji, let me ask you, where do you stand on this? Do you believe that two individuals should be seen equally under the eyes of law? That's the core concept of law. But if my personal law is different from your personal law, who deserves justice? How will justice be served?
Number one, we are bound to pay the respect to the order of any court. But my own opinion, whatever is written in Quran, I'm telling about the Islamic law or Shariat law. Whatever is written in the Quran, it is absolutely correct. If anybody is giving any opinion, whether Maulana or any person of having little knowledge like me, and he is giving opinion in the light of Quran, then he is 100% absolutely correct. And there is no need to change and amend the opinion of the same person. But if a person, because there are so many planted persons also there. So if any person is giving opinion on his own way, then he may be right, he may be wrong. This is my own opinion. But we cannot rule out anything which is written in the Quran if we are giving any opinion, observation, or anything which is written in the Quran and Hadith. Then this is my own view that this is 100% correct.
No. What I'm asking you, Asghar ji, is not about what your personal faith is. Quran is about faith, okay? When we are talking about working on personal laws fall outside of personal faith. It's not the fight of, it's not about prayer or it's not theology. It's about the practice in public life. So there's 5 aspects: marriage, divorce, death, inheritance. Now these are the 5 aspects. Now, when we are looking at one nation as Bharat, which is which has multiple communities, people from different walks of life, multiple jatis, multiple varnas, multiple panths, and when there is a cross section of people, and you have a law that governs it, the directive principles of our constitution mandate a common code, Aishwarya Mudgil, then in such a case, should we have multiple personal laws? And I am not restricting it only to Muslim personal law. Even among the Hindu communities, even among Christians, even among Baudh, even among everybody, Parsis, everybody else. Every community, every sect, every people have different codes of personal law. So, should my personal law supersede Asgarji's personal law, or Asgarji's personal law supersede Aishwarya's personal law? Or should we all be bound with one common law as far as personal laws are concerned? So that's why Aishwarya ji, and then I'll come to Asgar ji.
I was talking about the Shariat law.
No, I understand, sir. Like I said, nobody is saying disrespect Shariat. I'm just saying in the larger context of Bharat, what should be prevailing? Aishwarya ji.
Good evening, Anand. Thank you so much for having me on your show. At the outset, I'm very pleased with the holding of the Kerala High Court that rejected the petition before it requiring a reconsideration of its decision on extrajudicial divorce of Khulla. As an Indian woman, I feel happy that this ruling will allow the women of a particular community in India to be treated at par with their male counterparts who have the right to unilaterally divorce their wives. More importantly, I feel as a lawyer, this ruling has put to rest the issue of divorce by women without concurrence of their husband in Islam, while giving adequate thought to Islamic laws and scriptures while making their observation. So, firstly, as you said, whether personal laws can be placed, can we have a hierarchy? No, absolutely not. The idea is that the law of the land should prevail and has to be respected at all costs. And this is what this case also talks about. So I'll now make 3 points. Firstly, the court in this ruling differentiated between Hadith and Sunnah, while re-emphasizing on the fact that often interpretation of Islamic law, in particular Sunnah, has been varied and different Islamic scholars have interpreted it differently. Hence, there is a need to have legal experts interpret it and give a uniform view as opposed to Islamic scholars who might give a varied interpretation. Hence, in the original ruling, there was an amicus curiae who was appointed who assisted the court in interpreting the scriptures from a legal perspective. Court also held that the opinion of Islamic scholars is of key importance, especially in matters concerning beliefs and practices. But at the same time, interpretation of law was the job of the court, ably assisted by legal experts. And that's why we need a personal law which can codify, which can put to rest such different interpretations and different treatment of women. So if you look at Hindu women, they are being treated very differently. At the same time, the concept in Islam is very different. And where do you find a middle path? How do you reconcile that? Maybe in Islam, how women are being treated, maybe in contravention of the constitution. And that's what the original ruling also talked about, that we need to allow women to have khulla without the concurrence of their husband, just to ensure that the promise or the right that has been enshrined in Article 14 of the Indian Constitution is given good regards to.
Correct.
Right? So that's why we need something that you can't possibly have a hierarchy, but at the same time, laws like the Constitution, POCSO, courts are increasingly moving towards an interpretation which would respect the law of land first and then the personal law. I mean, we looked at this in the Sabrimala judgment, and that's where also barring the dissent, the majority held that women should be allowed to enter the temple. Why was that? Because they said that women should be given equal rights. At that time also, maybe the rights of the deity were not respected. Right, but the law of the land prevailed, and that's what is happening in this case.
No,
and
but see, I'll tell you. See, Sabrimala is a very different case because the rights of the deity are an individual's right cannot be superseded to protect the right of another individual. So it.
But again,
no. Let's not bring it. Yes. Let's not bring that in here because the rights of the deity is perennially youth. Perennially, a 14-year-old has a right to protect himself and the rules of that deity is because that area is the deity's home. So I cannot decide what can happen in Aishwarya Mudgil's house and who can enter Aishwarya Mudgil's house without Aishwarya Mudgil's permission. It's the same case with Sabrimala. So we're digressing. I'm coming back to this. Here, I'm not even looking at man and woman here. Yes, there is an issue where I am looking at equal rights, equal justice. So if under personal law, me and another person, let's say me and Asgarji, we
Yes.
enter into a contract. Now, in
Yes.
this contract, the contract is supposed to be done a legal contract. But when the breaking of the contract or annulment of the contract happens, if one party says my personal law says this and that should supersede, how does a court interpret this, Asgarji? What we have seen is, although the Kerala and Karnataka courts have sent one opinion, there have been cases in the Delhi High Court and other high courts where personal law has superseded what the actual law, codified law states. So there is also variance from court to court. Don't you think it should be uniform?
It should be uniform, and Anand again mentioned.
Aishwarya, 1 minute. I'm just going to bring Mr. Azhar Khan and then I'll
Yes,
come back.
Sure.
One nation,
Sure.
one nation with one law. This is correct, but this is a very wide topic. It needs a big discussion among the religious clerics and other persons, intellectuals. But as well as the question of this thing, acceptance of law as per the as Shariat law, then if we are not ready to accept the personal law since last 75 years, since the day of independence, the same law and same things and same tradition and same etiquettes and same law is prevailing till today. But what is the need to change everything?
Because, sir, the
today?
directive principles
Though
of our
everybody is-
constitution, Asgarji, the directive
No,
principles
no,
under the
no
directive
need.
principles, a common code is mandated under the directive principles. And our founding fathers wanted a common code. You would also go back and see it was our first Prime Minister who said that certain community groups are not yet reformed enough or ready to accept a common code. My point, sir, is today, if you are looking equality as justice,
I think they
justice has to be equal. आप मानते हैं? असगर जी, आप मानते हैं?
all right, sir, but there is no need. There was no problem with the pupils residing here since 75 years.
No, there have always been.
they are,
Sir, the issue of Shabano came,
no.
the first demand for a common code came in the 1950s.
It was solved by the Supreme Court.
Sir, the first. Sir,
If any such problem come into the picture, then courts are there.
no, but the
Shabano
courts have,
case,
the
problem
courts have
was
also
created
time and
and
again.
the
Your
Supreme Court will
is-
solve the problem.
Sir, you have multiple judgments of the Supreme Court which has directed the government and the centre to come to formulate a common code across the board. The courts itself have multiple times opined on it. So much so that the courts got superseded
if any
when they
such-
wanted to
this-
decide. Sir, since 1956, there have been people from all walks of life who have demanded a common code in our country, but politically it has been deterred because there have been pressure groups that have been built. I am asking you, Aishwarya ji, final question. I am asking you, how difficult or easy
such
it is.
problem
It's
come
not.
into the picture,
See,
then there
what
are
happens is in a common code, it's very easy to make it a Hindu versus Muslim aspect. It's not a Hindu versus Muslim aspect. Even among Hindu communities, even among region specific, north versus northeast. In the northeast, it's matriarchal. The rights of the woman supersede the rights of a man. In many communities, they are matriarchal. In many castes, there are different rules which apply. So now, how easy or difficult is it for us to arrive at a common code? Because in our country, go ahead, please.
Please, I'm sorry, please.
No, please. Please make your point.
So I don't think practically it's going to be easy because as you correctly mentioned, it's not just a Hindu versus Muslim versus Christian debate. Every region, various subcastes, castes, communities, everybody has a different religion has a different practice. And it's very difficult to sort of codify all of that into one single code. But at the same time, we'll have to start somewhere just because we can't hold ourselves back from something as progressive as UCC just because tomorrow there may be litigation or there may be a lot of hurdles in bringing about something. Nothing is easy, but a starting point has to be there. We'll have to place all religions equally. As I previously mentioned, we can't have one religion where law of the land is not respected or constitution is not respected, but for my religion constitution is respected or constitution is taking away my rights. So something like that shouldn't happen, can't happen. It is not going to be easy practically, but a starting has to be made. and eventually maybe few decades from now we'll be able to come at a
No, but why
place
should it
where
take a few
it will be
decades? If you can decide the minimum age of driving is 21, the minimum age, or 18, the minimum age of marriage is 18 and 21, minimum age for voting is 18. Now, in all these cases, marriage is personal, comes under personal law. Now, why can't the best practices of various communities be taken together and put together and said, no, this is what it is, and everybody in this country has to follow? Because otherwise, everybody will turn around and say, no, I will look at constitution like this. I different meaning of nationhood is like this. It will not stop at personal law only. Why can't there be, see, if there is a very great, fantastic process of divorce in the Christian community or within the Muslim community, use that issue. If there are rules for inheritance which are very good, let's bring that together from other communities. If there are rules for adoption which are kept, there are rules for birth and death which are kept, and property, etc. Why can't they all be amalgamated and made it a uniform code for everybody in the country?
Because Anand, who decides this is good? Good is a very subjective thing, right? So for what is good for maybe one community may not be good for someone else. So who decides, and how do you decide which one is good?
Right.
Maybe Muslim laws permit, and even the courts have said
No, but there are a lot of laws where decisions have been made saying that this is what is good for the country. So some people put their minds together and they've been doing so, they've done it. So if it can be done, if the will is put, then it can be done. Will it be done? That's a big question. I have to wind up. Asghar Khanji and Aishwarya Mudgal, thank you very much. That's all we have time for in this edition of The Right Stand. Stay with us. Brass Tacks follows.